Hello, and you're very welcome to week 3 of the Advanced Representative Employment Law module. And this week we're going to be looking at working hours. And in particular, we're going to be looking at the Organisation of Working Time Act 1997. We're going to look at maximum weekly working time. We're going to look at rest, definitions and exemptions, annual leave, holidays. We look at public holidays, Sunday premium, 0 hours, banded hours, record keeping, and again we will look at complaints and how complaints under the Organisation of Working Time Act are dealt with. Now, the Organisation of Working Time Act 1997, and just I suppose to inform that any of you who look at these pieces of legislation, if you have the interest and you're going to look at it online, all of the employment law that we look at have what's known as a preamble. So at the beginning of legislation, there's what's known as a preamble, and it's a short paragraph that describes what the legislation is about, where it's come from, and what it's trying to achieve. So the Organisation of Working Time Act, as you remember, at week 1 we spoke about source of Irish law, and we looked at the influence of European law and Irish employment law. So in this preamble, we can see that the Organisation of Working Time Act is an act to provide for the implementation of Directive 93/104/EC of the 23rd of November 1993 of the Council of the European Communities concerning certain aspects of the organisation of working time, to make provision otherwise in relation to the conditions of employment of employees and the protection of the health and safety of employees, to amend certain enactments relating to employees, to repeal the Conditions of Employment Acts 1936 and 1944, the Holidays Employees Acts 1973 and 91, and certain other enactments, and to provide for related matters. So in short, the Organisation of Working Time Act 1997 came from a European directive which was issued in 1993 by the Council of the European Communities, and it is predominantly a piece of health and safety legislation. So in providing rest periods and annual leave and breaks, you're looking at the health and safety of employees. That's predominantly the Organisation of Working Time Act. And I just want you to consider, I suppose, for next week, as this is a directive, what does a directive mean? So we looked at week 1, we looked at there are 3 ways in which legislation or law can come from Europe. There are regulations, directive, and so just understand the directive, how the directive gets transposed into Irish law. So just flick back to week 1, your slides, and just look at European legislation. So who is covered by the Act? And again, when we go along through the various weeks, legislation applies, of course, to employees. We looked at that at week 2. But there are certain employees who aren't covered by certain pieces of employment legislation. So we're going to look at who is covered by the Act. So all workers are covered by the Act, unless they are members of the Defence Forces or members of the Garda Síochána. Now, Part 2 of the Act, which deals with rest periods and weekly working hours, does not apply to junior hospital doctors in training, to fishermen or those working at sea, those in control of their own hours, prison service, fire service, coast guards, paramedics, etc., or family employees working on a farm or in a private house. So the Act doesn't cover members of the Defence Forces and members of Garda Síochána, and when we look at rest periods and weekly working hours, it does not apply to the workers we have seen listed here on this slide. So the maximum weekly working hours. There is a maximum average working week of 48 hours. It's averaged and it may be balanced out over a 4, 6 or 12-month period depending on the circumstances, and that's what's known as the reference period. So for night workers, the reference period is usually a 2-month period. For employees generally, for most employees in this state, the reference period for calculating your 48 hours, your average working week, will be over a 4-month period. For employees whose work is subject to seasonality, a foreseeable surge in activity, or who are directly involved in ensuring continuity of service or production, the reference period, the average working week, is averaged out over a 6-month period. For employees who enter into collective agreement with their employers, which is approved by the Labour Court, it can be up to 12 months, the reference period. And for young people under 18, the hours are fixed by the Protection of Young Persons Employment Act 1996. So for most of us, the reference period will be 4 months. So what that means is that I could work 60 hours this week and maybe next week. And the following weeks after that, I may work 39 again, may work 60, but it's the average is all the hours I've worked in the 4-month period when divided out by the number of weeks. You know, if it comes below 48 hours, then the employer's not in breach, or I'm not in breach of the Act. So that's how it's averaged out, and that's what's known as the reference period. Now, working time and time at work. Is there a difference? There is a difference, because not all time you spend at work is actually working time. So the Act defines working time as any time that the employee is at his or her place of work or at his or her employer's disposal and carrying on or performing the activities or duties of his or her work. Therefore, time at work excludes meal breaks, meal and rest periods, whether paid or not. So you could be at work for 50 hours every week, but by the time your breaks, meal times, rest periods are taken into account, you may actually be working less than 48 hours. Okay, we're looking at daily rest periods now. So daily and weekly rest periods. So in any one day, you are entitled to 11 consecutive hours of daily rest per 24-hour period. And that's the interval between daily finishing and starting times must normally be at least 11 hours. In any one period of at least 24 hours, so in any week then, you're also entitled to one period of at least 24 hours rest per week, preceded by a daily rest period, i.e. 11 consecutive hours, which is a total of 35 hours. Or if you work a 2-week roster of 14 days work, you are entitled to 2 by 24-hour weekly rest periods. If consecutive, must be preceded by one daily rest period. If not, each to be preceded by a daily rest period. So that's the daily and the weekly breaks. Now your rest breaks, and apologies if my visual, I'll just come off camera for a moment. That's just possible there now. And anyway, you're entitled to 15 minutes break where more than 4.5 hours have been worked. And that's, I just pause that for a moment. Let's see if I can come off the camera. Okay, there we go. And hopefully you can still hear me. So it's 15 minutes where more than 4.5 hours have been worked, or you're entitled to a 30-minute break where more than 6 hours have been worked, which may include the first break. Now, shop employees who work more than 6 hours and whose work include the hours 11:30 a.m. to 2:30 p.m. must be allowed a break of 1 hour, which must commence between the hours 11:30 a.m. to 2:30 p.m. So there are separate provisions for shop employees. And daily and weekly rest periods continued. The Act allows for flexibility in these rest arrangements. These rest periods and rest intervals may be varied if there's a collective agreement in place approved by the Labour Court, or if a regulation has been made for a particular sector. If there are variations in rest times and rest intervals under agreements or in the permitted sectors, equivalent compensatory rest must be available to the employee. And it's up to the employer to ensure that the employee has available equivalent compensatory rest. And there is a code of practice on compensatory rest periods If you remember, we talked about statutory instruments at week 1, which are secondary or delegated legislation. But statutory instrument number 44 of 1998 deals with compensatory rest periods. So there is a separate statutory instrument, a code of practice on compensatory rest periods and how they must be applied. Now, night workers. Night time is defined as the period between midnight and 7 a.m. the following day. A night worker is defined as an employee who normally works at least 3 hours of their daily working time during night time, and the annual number of hours worked at night equals or exceeds 50% of annual working time. Cannot work more than an average of 8 hours in 24 hours when averaged over 2 months. So you remember in the table a couple of slides back, we spoke about the reference period in relation to 48 hours. For most workers, it's generally 4 months. But for night workers, that reference period is 2 months. So they cannot work more than an average of 8 hours in 24 when averaged over 2 months. Night workers whose work involves special hazards or heavy physical or mental strain cannot work more than 8 hours in a 24-hour period during which they may perform night work. Now, again, with a lot of the employment legislation, there are certain exemptions, what are known as exemptions from the Act. So the Organisation of Work and Time Act permits exemption from the rest provisions if there are exceptional, unusual and foreseeable circumstances. Equivalent compensatory rest must be provided. Now again, just for yourselves, just to consider what situation might arise where an exceptional, unusual, or unforeseeable circumstances may arise. Some of you may have examples of this from your own workplace, and if you have, we'll discuss it again, or you might, I suppose, share it with us when we meet at week 3. Now, the Act provides for automatic exemption from the daily and weekly rest period provisions for shift workers when they change shift and for workers on split shifts. Equivalent compensatory rest must be provided. Again, I think there may be 1 or 2 of us involved in the class who work in manufacturing, but just to consider how the automatic exemption from the daily rest period and how it operates within manufacturing and why it might be there. And there's also exemption by regulation for paramedics, firefighters, etc. And there is some exemption by collective agreements. We're looking at registered employment agreements and registered employment orders, etc. So there are certain exemptions. Now we look at holidays and annual leave. There is no service qualification, and an employee starts to accumulate an entitlement to holidays from the moment their employment commences. All employees, regardless of status or service, qualified for paid holidays. All time worked qualifies for paid holiday time, including overtime. And certified sick leave and annual leave are now counted as time worked. And that has been a recent development over the last 5-6 years. And for employees who work more than 8 months in a year, 2 weeks unbroken leave must be provided unless an ERO or an REA collective agreement says otherwise. So for most employees, once you work 8 continuous months, you are entitled to 2 weeks unbroken leave. Now, depending on time worked, employees' holiday entitlements should be calculated by one of the following methods, whichever is the most favourable. So it's 4 weeks where 1,365 hours are worked in a leave year, and that would be most full-time employees. Or it's 1/3 of a working week for each month worked in the leave year, or 8% of the hours worked in a leave, maximum 4 weeks. So the 8% calculation normally applies to part-time workers, but the employer must apply one of these 3 methods, whichever one is the most favourable. But just to say that the 1,365 hours will apply to most full-time employees, whereas the 1/3 of a working week for each month worked in a leave year, or 8% of the hours worked, will apply mostly to part-time workers. But the employer must apply whichever one of these methods is the most favourable to the employee. The employer decides the times at which annual leave is taken, subject to need for employee to reconcile work and family responsibilities and the opportunity for rest and recreation available to the employee. And the employer must consult the employer trade union 1 month before the leave is to be taken. Leave is to be taken in the leave year, extendable by employer by 6 months with employee consent. And if the employee cannot take leave in the leave year due to certified illness, they can carry it over for 15 months. Now, some of you may be surprised that it's the employer who decides when the annual leave gets taken. Some may not, but for some people we have found in delivering this course, they are surprised by that. However, notwithstanding, the employer must still consult with the trade union 1 month before the leave is to be taken, and the leave to be taken in the leave year. Now, under the Organisation of Work and Time Act, the leave year begins on the 1st of April. But for most of us now, our leave year begins on the 1st of January. But for the purpose of the Act, the leave year does begin on the 1st of April of each year. Now, holiday pay. The pay for annual leave must be given in advance of the commencement of the employee's annual leave and is calculated at the normal weekly rate. It is illegal to pay an allowance in lieu of the minimum statutory holiday entitlement under the Act unless the employment relationship is terminated, when a balance payment may be paid for holidays owed to the departing employee. And public holidays. There are 9 public holidays. The Act does not refer to bank holidays because not every bank holiday is a public holiday. For example, Good Friday. Employees other than part-time have an automatic entitlement to public holiday benefits. Part-time employees must have worked at least 40 hours during the 5 weeks ending on the day before the public holiday. Public holiday entitlements. Now, in respect of each public holiday, an employee is entitled to a paid day off on that day, a paid day off within a month of that day, an additional day's annual leave, and additional day's pay, as the employer may decide. Now, if the public holiday falls on a day in which the employee does not normally work, then the employee is entitled to 1/5 of his or her normal weekly wage for that day. Now, for most of us or some of us in unionised employment, working on the public holiday would usually attract premiums like double time for some time and a half, but more often than not, it would double time. I know some companies that if you work on the public holiday, it pays treble time. So public holiday and sick leave. If you are a full-time worker on sick leave during a public holiday, you are entitled to benefit for the public holiday you missed. If you are a part-time worker on sick leave during a public holiday, you are entitled to benefit for the public holiday, provided of course you work for your employer for at least 40 hours in the previous 5-week period. However, if you have been off work for more than 26 consecutive weeks due to illness or accident, or for more than 52 weeks due to an occupational accident, and you are absent from work immediately before the public holiday because of this, you are not entitled to the public holiday. You are entitled to leave for any public holidays that occur while you are on maternity leave, parental leave, paternity leave or adoptive leave, and these leaves are also known as protective leave. Now, the Act itself is silent on how a public holiday should be dealt with while someone is on sick leave. Now, some of you may have been sick on sick leave during a public holiday, so I'd be interested to know how your employer has applied it. Okay, Sunday premium now. If you work on Sundays, your entitlement to extra pay may be agreed between you and your employer through your trade union. And for most of you taking this course, your Sunday premiums will have been negotiated for you on behalf by your trade union. Now, for most employees who are not trade union members, again, this legislation will apply. And again, we're looking at the floor, the minimum legal entitlement. So under the Organisation of Work and Time Act, if there is no agreement about your pay, your employer must give you one or more of the following for Sunday working: a reasonable allowance, a reasonable pay increase, reasonable paid time off work, or a combination of the above. The Act says no more than that. It doesn't say what a reasonable allowance is. It doesn't say what a reasonable pay increase would be. Reasonable paid time off work doesn't give any indication on that. And again, there's a Labour Court recommendations which deal with the issue of the reasonable allowance. So while the Organisation of Work and Time Act states that employees are entitled to a Sunday premium, either a reasonable allowance or reasonable pay increase, they don't say exactly what that should be. And these issues have been tested in the Labour Court, and the Labour Court have issued recommendations in what a reasonable allowance would look like. So, what is reasonable, again, depends on all the circumstances. Now, we're just going to have a look at some of these Labour Court recommendations. In this case, known as Chicken and Chips Limited, trading as Chicken Hut, and David Malinowski, the court considers a premium of 33% of the hourly rate is reasonable. So in relation to Sunday premium, in this particular case, where David Malinowski took a case against Chicken Hut, the court considered a Sunday premium of 33% of the hourly rate to be reasonable. In another case, known as Viking Security Limited versus Valent, the court measures the level of compensation for working on Sunday that is reasonable in all the circumstances at time plus 1/3 for each hour worked on Sunday. Now, like I said previously, for most in unionised employments, working Sundays usually gathers a double time premium. But the court has found the reasonable allowance to be time plus 1/3 for working Sundays. And there is a code of practice on Sunday working, specifically in relation to retail and related matters, and that is Statutory Instrument 444 of 1998. Again, that was the 444th statutory instrument issued in 1998. Now, we're going to look at 0-hour contracts. And I touched on this slightly last week when we were looking at an employee's entitlement to the 5 core terms within 5 days of commencement of employment. And I was explaining during the class why it is important for some workers to know to have in writing the reasonable amount of hours that they're expected to work in every week. And it is in relation to 0-hour contracts. Now, 0-hour contracts are prohibited under the Organisation of Work and Time Act 1997, Section 18, except in the following circumstances. So where the work is of a casual nature, or where the work is done in emergency circumstances, or short-term relief work to cover routine absences for the employer. So 0-hour contracts are now prohibited, but they are allowed where the work is of a casual nature. And again, if you want to go back to our slides from last week when we were looking at the various types of contracts, we did mention a casual contract. So just familiarise yourself what a casual contract is, what it looks like. The 0-hour contract doesn't apply where the work is done in emergency circumstances or short-term relief work to cover routine absence for the employer. Now, when the calculation is done under Section 18, the new minimum payment is 3 times the national minimum hourly wage, or 3 times the ERO rates where applicable. So where it is found that the employer has breached Section 18, the calculation of compensation will be 3 times the national minimum hourly wage, and at the moment that is €10.10. So that would be 3 times by €10.10, which would be €30 and 30 cents. Now, an employee under a 0-hours contract who works less than 25% of their potential hours in any week should be compensated. Now again, while the Organisation Working Time Act Section 18 dealt with 0 hours, legislation really didn't come in to clamp down on 0 hours until March of last year. And we did speak slightly about that last week. So from March of 2019, 0 hours are now prohibited. And that's when the 5 core statements to be issued to all employees came in as well as law. So the level of compensation depends on whether you got some work or none at all. So for example, if you got some work, your compensation should bring you up to 25% of the possible available hours, or 15 hours, whichever is less. And we'll expand on this a little bit in a moment, so don't get too worried about it. So if someone got no work, the compensation should be either for 25% of the possible available hours or for 15 hours, whichever is less. Now, an example of that. So if I work in a local cafe and under the 5 core terms, under the Terms of Employment Information Act, the 5 core statement that I was given, we say, for example, the expected hours I'm to work every week was 20. In a week, for example, where I got no work, I would be entitled to be compensated for 15 hours or 25% of the 20 hours, which is 5 hours, whichever is less. So in this case, even though my contract says I'm entitled to 20 hours work and I wasn't called into work that week, I'm still entitled to be paid 5 hours pay. So prior to this, the 0 hour system worked on sort of like, we need you, we'll call you. So workers didn't have a contract that stated their expected weekly hours. Now, I suppose the beauty of the legislation that was passed March 2019, an employer is now obliged to give an employee in writing the hours that they're expected to work every week. And it's from those expected hours then that the calculation, when they don't get work, is used in which to calculate what they're entitled to. So if I was expected to work 20 hours a week and in a particular week I wasn't given any hours, the employer is still obliged to pay me 5 hours. Now, if on the other hand, we say, for example, I went into work and I got 3 hours and then I was told, look, to go home, it's quiet. So I've only got 3 out of the 20, I would still be entitled to be compensated for 2 hours to bring me up to the 25% of the contract hours. So to calculate the minimum payment in this example, €10.10 per hour is the national minimum wage. Alternatively, I could substitute the ERO hourly rate if this applies to the job. Now, so where you got no work, it's €10.10, the national minimum wage, by 3 times. So this calculation, how it works, it's €10.10 by 3, which is €30.30 by 5 hours, which I would be entitled to one payment of €151.50. If I got 3 hours, it's 10.10 by 3 by 2, which would be 60 hours, 60 I would be entitled to. That's how the Organisation Working Time Act deals, or that's the calculation for the payment of hours that I'm not provided with. Now, you can understand in this situation that if I have a contract, it would be in the employer's interest to bring me into work for the 5 hours or the 6 hours, whatever the 25% of normal hours is, because it would only have to pay me €10.10 by 5, rather than have to pay the compensation of 10 by 10 by 3 by 5. So it would be €50.50 versus €151.50. And the minimum payment rate does not apply if you are on call. Now, with the legislation that came last year, it also introduced what's known as banded hours. Now, for most of us on this course, you're SIP2 members. SIP2 and Mandate pushed hard for the prohibition on 0 hours. The banded hours, I have to say, and give credit where credit's due, was something that Mandate Trade Union pushed for and fought very hard for, specifically to deal with Dunnes Stores and the difficulty they have as a trade union in trying to negotiate with Dunnes Stores, who have a tendency just to ignore that trade union. Now, just for a way of history, I was involved many years ago, SIPTU and Mandate, because SIPTU had about 6 Tesco stores across the country. It was a situation where a lot of Tesco workers would have come in on maybe 15 or 18 hour contracts. And over the years, with the stores getting busier, found themselves maybe working 35 hours a week, and had been working 35 hours a week for maybe 1 year or 2 years. Now, when the Lidls and the Aldis opened next door or close to the Tesco's or in those towns, a lot of footfall moved, and the Tesco stores found a downturn, of course, in their sales. And of course, the store manager, in trying to equal out the books, reduced those who had been working maybe 35 hours for the past 2 years, reduced them back down to their contracted hours of maybe 18 or 15 hours. So in some circumstances, you had employees of Tesco losing out on 50% take-home pay. So where they had a standard of living had become established because of the amount of hours they were working every week, to find their take-home pay to be cut by 50% or more was untenable. So Mandate and SIPTU set about trying to negotiate what was known as banded hours with Tesco. And that gave for our members certainty of earnings, and that's what we were trying to establish within the business. Now, how it worked was we agreed that anybody who had been working, we say 35, 33 hours for over a year, would work within a 30 to 35 hour band. They would be given a 30 to 35 hour band. Now, what that meant, if there was a downturn in business in the store, that the most they could lose was 5 hours. So if I was working 35 hours, we say my contract says 18, but for the past year I've been working 35 hours. With a downturn in business, the most or the lowest I could drop to was 30 hours. So for anyone who might have been working 28 hours, they would be in the 25 to 30 hour band. With a downturn in business, they could drop back down to 25 hours at the most. So the most that someone could lose was maybe 5 hours a week, which guaranteed at least some certainty of earnings. Now, Mandate, in fairness, and SIPTU, we agreed that with Tesco. Mandate then, I think, had that agreement with various other retail outlets, I think Marks and Spencer's and some others. They were having huge difficulty with Dunnes Stores. So this banded hours then that came in under the Protection of Employees Miscellaneous Provisions Act of 2018, which became law in March 2019, included banded hours. And what that means is, where employees' contract or statement of term does not reflect the realities of the hours worked over the reference period, and the reference period in this case is 12 months, what happens is the employee then makes a request to their employer in writing. So if I have a contract for 15 hours and the last year I've been working 30, I write to my employer requesting a banded hour contract. So the employer has 4 weeks in which to consider my request. The existing employees need not wait, and the section does not apply the banded hours provided through collective agreement. So if there's already a collective agreement there, it doesn't apply. But in this particular case, those employees who are working more than their contracted hours over the 12-month period wrote to Dunnes Stores at that time seeking banded hour contracts. And if the contract was given, you are entitled to that for at least 12 months. Now, the employer must agree unless the facts don't support the claim. So if I made a written request seeking a 30 to 35 hour banded contract, the employer's records are showing that no, on average I've only worked 25 hours, then if the facts don't support the claim, they don't have to agree to the contract. Now, significant adverse changes have impacted on the business or in emergency circumstances, or the employer must agree unless hours worked were genuinely temporary, i.e. if I was covering for someone on maternity leave. So the bands that the legislation has introduced is 3 to 6 hours, 6 to 11 hours, 11 to 16 hours, 16 to 21, 21 to 26, 26 to 23 hours, 31 hours to 36 or 36 or more. So they're the bands. Now, the last time I spoke to a colleague in Mandate Trade Union, I think they've secured well over 6,000 or 7,000 of these banded hour contracts for their members within Dunnes Stores. Now, back to the Organisation Working Time Act, record keeping. The records are required to be kept by the employer, are prescribed by, again, statutory instrument number 473 of 2001, Organisation Working Time Records, prescribed form and exemptions, regulations of 2001. Long-winded title, but it's SI number 473 of 2001. These records must be maintained for 3 years and must be available for inspection by inspectors of the Workplace Relations Commission. We'll talk a little bit more about them next week and the service they provide. Employers are required to keep the following records: the number of daily and weekly working hours, excluding meals and rest periods, leave granted in each week by way of annual leave, public holidays and payments made, weekly record of the notification of starting and finishing time of employees. So record keeping is very, very important under the Organisation Working Time Act. Again, just consider, why is record keeping important? Why is it important? And maybe think about the preamble and what the legislation is trying to achieve for workers. Now, complaints. Again, this is probably the first week that we have looked at a specific piece of employment law. At week 1, we looked at source of law. At week 2, we looked at contract. Now, we did talk about various pieces of legislation, Terms of Employment Information Act, in relation to your entitlement to the 5 core term statement. And we looked at the Unfair Dismissal Act. But this week, I suppose we're looking specifically at a piece of legislation. Now, where there are breaches of legislation, there will be complaints, of course. So every week we will have a look at the complaints, who the complaint is made to, and the time limits by which a complaint must be made. So right of complaint under the Organisation Working Time Act is to the Workplace Relations Commission, the WRC, where an employee believes there has been a breach. The complaint must be made within 6 months of the breach. Now, this is extendable by the adjudicator to 12 months with reasonable cause. Now, if the adjudicator, after hearing the case, decides that there has been a breach, they can grant or recommend a remedy. So the remedy must be one or more of the following. They will make a declaration that the complaint was or was not well founded. They require the employer to comply with the relevant provision, and compensation, if any, is due up to 2 years, a maximum of 2 years. Now, complaint for no minimum payment under the 0 hours, under section 18, 0 hours, they can award compensation using the formula that we looked at. Now, if a complaint is made under banded hours, we'd say, for example, an employee is making a complaint against their employer that they've refused to give them a banded hour contract, having requested it, the WRC can make an order for the hours to grant the contract, but there is no compensation for the employee for not receiving the contract at the time of request from the employer. And there's a complaint for penalisation under the Act, the compensation of up to 2 years. Now, penalisation is something we will look at over the coming weeks as well. But what penalisation means is that the employee, having made a complaint under the Act or seeking their entitlements under the Act, is penalised by the employer. Now, that penalisation might be redeployment, it might be demotion, it might be actually dismissal. So you can take a complaint for penalisation under the Act as well. And the compensation can be paid up to a maximum of 2 years your annual salary. And of course, all WRC recommendations or decisions can be appealed within 42 days to the Labour Court. Now, WRC inspectors can be appointed to investigate the workplace. Inspectors have the power to enter premises and inspect records. Where an inspector is satisfied that certain contraventions have occurred, they may issue a compliance notice on the employer setting out the actions to be taken by a specified date. The employer can appeal the notice to to the Labour Court. And failure to comply with a notice is an offence. So, for this week, I want you to consider, and we'll have a discussion in class, just to familiarise yourself with what workers are covered by the Organisation of Work and Time Act 1997, to be able to explain the difference between working time and time spent at work, to know what rest breaks employees are generally entitled to consider does the Act permit exemptions from the rest provisions, and if so, to what context, how long does an employee have to be working for in order to accumulate an entitlement to annual leave, is it legal for an employer to pay an employee in lieu of annual leave, do all employees have an automatic entitlement to public holiday benefits, and are 0-hour contracts permitted under the Organisation of Work and Time Act 1997. Just to consider, and if you know these out of this week, out of these slides, well then, you have a good understanding of the Act and what the Act is about and what it's trying to achieve. And just references, that's just where I got some of my information from. That guideline, by the way, is a very good guide to employment, labour and equality law. So it's the guide that we will use when we do our open exam at the end of the course. Now it's available online and I'll be sending it out to you, so don't worry about it at all. So look, I've taken up 40 minutes of your time. It's enough. And I will see you hopefully at week 3 in the class or online next week. So look, in the meantime, have a good week, and we'll talk next week when we meet in class. Slán.